Welcome to this short video lecture on treaties, which are a major source of international law. This video answers questions such as: what exactly is a treaty? How is it defined? What categories of treaties do we have, and how do the various kinds of treaties differ from each other? What does it take for a treaty to come into existence? How are treaties made? Let's take Article 38 of the ICJ statute as a starting point. Do you remember that article? It offers us an overview of the sources of public international law. And what is mentioned first are international conventions, in other words, treaties. In Article 38 of the ICJ statute, treaties are top of the list of the sources of public international law, and they are a central source of law indeed. Today, there are tens of thousands of treaties in force. Much of public international law is to be found in treaties. Yet, what exactly is a treaty? How is it defined? What do we need in order to have a treaty? Luckily, we can find the definition of the notion of a treaty in the Vienna Convention on the Law of Treaties, the VCLT. When it comes to treaties, the VCLT is essential reading. It is the heart of treaty law. In fact, the VCLT is itself a treaty, and it is a treaty that provides fundamental rules applying to treaties. It's very much a treaty on treaties. In its Article 2, the VCLT contains a number of definitions. The first notion that is defined here is the treaty. Article 2, paragraph 1a states that for the purposes of the present convention, treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. As we can see, there are four elements that define a treaty in the sense of VCLT. We need an international agreement that has been made between states, that has been put into written form, and that is governed by international law. The definition also mentions what is not important. You have it at the end in the phrase, whatever its particular designation. As long as a document contains an international agreement between states, its title is irrelevant. It does not matter whether it is called a treaty, an agreement, a convention, a covenant, a protocol, pact, or whatever. It's all the same. However, treaties do come in different forms and shapes. There are different categories of treaties. Let's have a look at some of those categories and also at the criteria that serve to distinguish them. A first distinction is between bilateral and multilateral treaties. Obviously, those are fairly straightforward categories, at least at first glance. Bilateral treaties are agreements between two states, whereas multilateral treaties involve more than two states. That is to say, a minimum of 3 states. Typical examples of bilateral treaties are double taxation agreements, DTAs, and bilateral investment treaties, BITs. Multilateral treaties are, for example, the European Convention on Human Rights, the United Nations Convention on the Law of the Sea, the General Agreement on Tariffs and Trades, and also the Vienna Convention on the Law of Treaties. Another important distinction is between self-executing and non-self-executing treaties. While self-executing treaties are directly applicable, non-self-executing treaties need to be implemented by national legislation. Whether a treaty is self-executing or not is ultimately not an international law question. It's something that ultimately depends on national law. National law determines whether a treaty shall apply directly within the territory of the state concerned. However, there are treaties that are typically meant to be self-executing and others that typically need to be implemented by national legislation. Let's take the example of the European Convention on Human Rights, to which, as you might know, Switzerland is a party. Well, is this convention directly applicable without implementation being needed? Yes, of course it is. If you feel that one of your rights guaranteed in the European Convention on Human Rights has been violated, you're able to directly invoke the convention and claim its protection. In other words, it's a treaty that is typically meant to be self-executing. On the other hand, treaties relating to international trade law, such as the General Agreement on Tariffs and Trade, the GATT, are typically meant to be non-self-executing. In trade disputes involving the GATT, only states can be litigants. The GATT does not provide individual rights to private persons or enterprises. Rather, it is the responsibility of the state parties to the GATT to align their national law to the free trade principles established in the GATT. Everything all right so far? Here you have a summary of what we did up to now. But let's turn to yet another question, the question of how treaties are made. What steps need to be taken for a treaty to come into existence? It's what we call the treaty-making process. Obviously, the whole thing always starts with some kind of negotiations between the states involved. If successful, such negotiations typically lead to a document being produced, some sort of a written agreement, which then is submitted to the representatives of the states involved for signing. That signing usually takes the form of a highly publicized ceremony. It comes as a great event, yet its legal effects remain rather limited. Signing does not make the states whose representatives have signed the treaty parties to that treaty. It only makes them signatories. Therefore, the treaty is not yet binding for those states. To become a party, each of these states still needs to ratify the treaty. Only when a state has ratified the treaty, it is bound by it. Ratification is the decisive step that puts the treaty into force for the state concerned. In contrast to the international treaty negotiations, the process leading up to ratification is national rather than international. It's a political process that takes place at the national level. The 1919 Peace Treaty of Versailles that ended World War I provides a good example. The international negotiations taking place in the Castle of Versailles, near Paris, were where American President Woodrow Wilson was very successful in convincing the representatives of the other states involved to adopt his program for the peace of the world, his famous 14 points, as the basis of the peace treaty and the related covenant of the League of Nations. However, when Wilson signed the peace treaty on behalf of the United States of America, he only made his country a signatory to the treaty, not yet a party. And when back in Washington, D.C., he ultimately failed to convince the US Congress, the American Parliament, to ratify the treaty. He lost the decisive battle in the national political debate over ratification, which meant that The United States of America never became a party to the 1919 Peace Treaty of Versailles and remained outside the League of Nations that was a central part of that peace treaty. So remember, signing and ratification are not the same thing. Those are very different steps. Ratification matters much more than the signing of a treaty. Ratification is the decisive step that brings the treaty to life. It's the starting point of the phase during which the treaty is implemented and applied, the time when the treaty is in force, which is the case until it is eventually terminated. Termination is the end point of the treaty's life cycle. And this also marks the end of this short video lecture. Thank you for watching.